Hello, I am a juror on the Jennifer versus AU Hospital case. After careful review of the Health Insurance Portability and Accountability Act, also known as HIPAA, I am presenting the following argument. Referring to 45 CFR 164.512E indicated that the protected health information can be released in response to a subpoena, discovery request, or other lawful process that is not accompanied by an order of a court or administrative tribunal if A. the covered entity receives satisfactory assurance as described in paragraph E1(3) of this section from the party seeking the information that reasonable efforts have been made by such party to ensure that the individual who is the subject of the protected health information that has been requested has been given notice of that request, or B. the covered entity receives satisfactory assurance as described in paragraph E1(4) of this section from the party seeking the information that reasonable efforts have been made by such party to secure a qualified protective order that meets the requirements of paragraph E1(5) of this section. In subsection A, it states that the party had to have made a good faith attempt to provide written notice to the individual, or if address is unknown, then mail a letter to the last known address, which is what AU Hospital did. It appears that AU Hospital did follow the required HIPAA guidelines to ensure patient privacy. It is unfortunate that the staff was not able to reach the patient prior to the release of the medical record. But according to the law, AU Hospital was permitted to release the requested information for this patient. The U.S. Department of Health and Human Services also provided information on privacy and court orders and subpoenas. Understanding that receiving a court order is not the same as receiving a subpoena. Under a court order, the HIPAA-covered healthcare provider may share the protected health information, and it is limited to the information that is described in the court order. A subpoena, when issued by someone other than a judge, such as a court clerk or an attorney in a case, is different from the court order. A HIPAA-covered provider may disclose information to a party issuing a subpoena if the notification requirements of the privacy rule are met. Before AU Hospital responded to the subpoena, they needed to receive evidence that there were reasonable efforts to notify the person who is the subject of the information about the request, so that the person has the opportunity to object to the disclosure or seek a qualified protective order for the information from the court. According to Hope Benefield from the University of Florida and the article titled Communication and Records, HIPAA Issues When Working in the Healthcare Setting, dated 2006, states, the HIPAA regulations clearly define the material that constitutes individually identifiable health information and the ways in which that protected health information, PHI, must be managed. She later explains that the access to PHI is limited to those who are directly involved with the patient's care, those who process the paperwork for proper recording, record keeping, or billing, and the quality assurance and training staff members. Keeping in mind that the PHI of any patient must be exclusively authorized for work-related functions and not personal amusement or entertainment. With medical information and psychiatric information being kept in the same medical chart, it could cause a problem for patients, especially when they are unreachable before their information is disclosed under the request of a subpoena. One option to consider is that the patient who's being treated for a mental illness such as anxiety and depression, as in Jennifer's case, could actually put a restriction on how their PHI is used. With the privacy and the confidentiality regulations that are mandated by our government and the HIPAA law, it has become apparent that each person needs to be aware of what is in their medical chart and provide caregivers with appropriate releases or restrictions of release accordingly. I am ruling in favor of the defendant in this case. Thank you. References: Benefield H., Ashkenazi G., and Rosinski R.H., 2006, Communication and Records. Court Orders and Subpoenas, 2016, U.S. Department of Health and Human Services. Hammer S., 2015, How to Properly Issue Subpoenas for Mental Health Records. And Health Information Privacy, 2016, Health and Human Services. Thank you.